Hello, this is attorney Jeremy Hogan and welcome to another Legal Briefs Crypto Edition. If you own XRP, prepare today to be happy, scared, sad, and hopefully happy again. Kind of like the first time you watched E.T. Bonus points if you can name the actress in the comments. Now, I found out some really interesting things this week in regards to the SEC lawsuit against Ripple. Things you probably have never seen before or heard about before. I was hoping to see the case management order filed earlier this week, but alas, it was not meant to be. But I found something even more interesting, so stick with me for 10 minutes as I tell you all about it. Now, I want to give you advanced warning. Parts of this vlog will be very speculative, some points just outright guesses. So please make sure not to take anything I say as legal advice. Although, I will have you know, my former law professor has said great things about me on TV.
I have no idea what he's doing. I have no idea why he's saying what he's saying.
Really, that's true. Law professors are kind of like that. In any case, as I'm certain you are aware, the price of XRP has exploded over the last couple days. I'm sure you are as happy as I am happy. So let's all swim laps in our pools full of gold coins. Very good, enough of the happy. Let's get to the scary part. You know how they say when investing, be fearful when everyone else is greedy and be greedy when everyone else is fearful. Well, everyone is happy greedy right now, so I'm going to start with a couple scary things that I've found out about the SEC versus Ripple litigation. I'm going to start with the proposition that this lawsuit is mainly about the XRP that Ripple holds in escrow and the sales of same. This is fairly obviously the sticking point to me, and I posed a question a couple weeks ago asking what would happen to the price of XRP if Ripple was not allowed to sell any of the XRP in escrow. Now, I received a lot of responses from you guys, which I'm very thankful for, but over the last couple weeks as I did my own research, I quickly realized that this is not necessarily a good thing. And the reason it's not a good thing is because Ripple would very likely fail or have to move to another country at the least if it was not allowed to sell the XRP that it held in escrow. Now, I can't recall who told me that. Wait, oh yeah, I can recall. It was the CEO of Ripple who said it. I also think on this issue, Matt from the Moonlando YouTube channel did a great job talking about the effect of Ripple losing the escrowed XRP. I'll link to that video below. He made it about 2 days ago, which for him is about 20,000 videos ago. That guy never sleeps. So with that in mind, it was brought to my attention by Mr. Yassin on Twitter. Thank you very much, Mr. Yassin, that the acting chair of the SEC, Allison released a public statement on February 11, which was yesterday, which was very interesting and concerning. So let's take a look at it. Let's take a look at what it says, and then we shall begin with the speculation. Recall that the SEC has two different parts, the regulatory part and the enforcement part. And this is very common. I see it every day in the insurance world. This is how regulatory agencies are set up. Now, the regulation part of the SEC passes rules and makes decisions on whether a filing is adequate, things like that. The enforcement section files lawsuits against those it thinks have broken the law. Now, looking at the first paragraph of the statement, Ms. Lee states that the SEC will no longer approve lawsuit settlements that where a settlement offer is conditioned on the granting of a waiver. That is the change in policy effective February 11, 2021. Before February 11, 2021, the SEC policy was the exact opposite. And here is the proof from former SEC Chair Jay Clayton. Look on page 2 where he says an offer of settlement can address both the underlying enforcement action and a waiver. So why is that important, you might be asking? Now stay with me here. This is kind of complicated, but super important to where I'm taking you with this. Now, under the SEC rules, when you have been determined to have violated the law, you lose certain privileges that the SEC provides companies. You can't take certain shortcuts. You can't do certain things under certain subsections. Commissioner Lee lays that out in paragraph 2 of her statement. And look at one of the privileges you might lose for violating securities laws. The privilege of offering securities under Regulation D. So what she is saying is that settlements of litigated cases can no longer include settlement terms which include anything related to offers or sales under Regulation D. And where is the last time we saw that exact settlement term referring to Regulation D? Now, you had to be paying attention, but that settlement term was in the Kick Interactive case final judgment from the lawsuit that Kick Interactive lost in 2020 and that we talked about a couple of videos ago. Look at paragraph 2 at the bottom. Quote, "Nothing in this paragraph requires defendant to seek the commission's approval prior to selling any covered asset." So what that means is that Kick Interactive negotiated into the judgment that it could still make use of all privileges under the SEC rules, including selling its coins under Regulation D, which it did. And what is Regulation D? We've talked about this before briefly, but Regulation D allows you to sell a security by just filing a simple form with the SEC, very simple and easy to do, as long as you don't advertise the sale, and 2, as long as you sell to an accredited investor, defined as an individual with over $1 million net worth or as a company. So the idea being that these entities are very sophisticated and don't need the SEC to protect them. So in effect, what Kick Interactive was able to get the SEC to include in the final judgment is that even though it had violated the law, it was not going to be put in kind of SEC purgatory where it couldn't sell its Kick coin, because that would have been horrible for Kick Interactive, even more so than it would be for Ripple. But what Ms. Lee is saying in her statement is that the SEC will no longer settle cases where the settlement terms include that the defendant can make use of Regulation D to sell its securities. And here comes the speculation, just giving you a heads up. I don't think the timing of this public statement was just random. First, remember that Ms. Lee is the acting chair, just waiting until Mr. Gensler is confirmed, and then he will take over. And this is not the sort of broad position statement you would normally see from a short-term chair. Second, this 180-degree change in a position usually doesn't just happen because, she's sitting there bored or just wants to write something or set out a statement. These statements come about because something happens that requires it. And I would proffer to you that this is what is happening. Okay, here we go. So the SEC filed its lawsuit in December and Ripple responded on January 29. Now during that time, Ripple is gathering its team and drafting an answer. That keeps you very busy. Then, after that took place, there were some phone calls, maybe even informal get-togethers between the SEC lawyers and the Ripple lawyers. Now, during those conversations, Ripple proffered a settlement which included terms that would require the SEC to allow Ripple to sell the XRP in escrow to accredited investors only. Repeat, Ripple for the most part caved and said it would pay the fines and agree not to sell any escrowed XRP to individuals, but only wanted to be deemed qualified under Regulation D so it could sell to big players and big companies. And here's where the speculation kind of gets even more scary. The SEC said no. No, we will not agree to that. If we settle the case with you, you will have to request a waiver from our regulatory department like every other rule breaker out there, and we will not agree based upon anything outside of our regulatory criteria if you're going to settle with us. So, what did Ripple do? They did what I would do. They went back to the Kick Interactive judgment, they pulled it out and they said, hey, SEC, look at this. This is what you did with Kick Interactive. Look at paragraph 2. You put that term in the settlement for them. You also have to do it for us. You are a government entity and it's a violation of due process to treat us differently than them. And then I would proffer that the SEC lawyers went back to Ms. Lee, who is acting chair of the SEC, showed her the email and said, they are accusing us of discrimination because we won't put the waiver in the settlement. And Ms. Lee said to them, don't worry guys, I got your back. I am a career SEC lawyer. I don't think we should be agreeing to that in general anyways. So I'm going to issue a public statement that the SEC will no longer approve settlement terms that include regulatory provisions in them. And I'm going to make it a blanket position statement, and therefore we won't be discriminating against anyone. We're going to treat everyone the same. And that is where I believe this document came from. And if I'm right, and remember, I usually am, that is a scary thing because it indicates that our worst case scenario has gotten even worse, because if things go as bad for Ripple as possible, which I'm not saying it will, but if they do, now our worst case scenario with Ripple losing the lawsuit means either one, their fate rests on some low-level SEC employee approving the Regulation D request, or two, and I think the more likely scenario, definitely would be Ripple moving operations to Japan or some other more friendly country. Now, could I be wrong? Of course, absolutely. But where else did this public statement from the temporary head of the SEC come from? Now, I'm very familiar with the SEC's litigation docket now after these last couple weeks, and there is nothing higher profile right now than the Ripple lawsuit. It's all just run-of-the-mill fraud litigation. Nothing, in my opinion, that is high profile enough to cause a complete change of a long-standing policy like this. But hold on one second. If I'm correct, think about what that means. If Ripple was truly talking about settlement, which included terms similar to those in the Kick Interactive case, that means that it would be agreeing to sales, in effect, only to companies and big players with lots of money. I think you guys call them whales. Now, the other caveat of the Regulation D sale is that the purchaser can't sell the securities downstream for at least 6 months. So the entities that would purchase the XRP would have to buy and hold them for at least 6 months. So again, if this is the case, Ripple knows it has purchasers of escrowed XRP who either are okay holding it for at least 6 months or just want to use it or hold it forever. Now, who those entities might be, I leave for those more knowledgeable to speculate on. But my takeaway is that Ripple knows it can survive with just Regulation D sales of XRP if that is necessary. And that makes me feel much better moving forward. So I hope that I leave you with some happiness and hope. Watch me next time as I speculate about airplane contrails and government mind control. Stay safe, and remember, even if XRP was Thanos snapped out of existence today, the sun would still rise tomorrow and life would go on.